All right, we're going to talk about business associations. We're going to talk about their legal structure. I will cover about six business associations. For those of you that are in my class right now, this is to help you with your writing assignment. Um, for those others that may come later, this is a supplement to your education, to the lecture. Okay, so we're going to talk about business organizations, how businesses are organized and why they're organized a certain way, what benefits those businesses have by being organized in this way, and some of the disadvantages of being legally organized in this way. So these are legal structures, okay, legal structures for businesses. Now, they don't have to be businesses. Some nonprofits can be organized this way. Some religious organizations can be organized very similar to businesses. You can have a nonprofit corporation. It's just that they have different limits. They have different challenges and limits, so they can't really issue stock. In some cases, they can't earn profits because they're non-profit. Okay, so all the money that comes in that would otherwise have been a profit, that would have been distributed to shareholders, or that would have been given out as a dividend, or something like that, that would have gone outside of the business organization, it stays inside. Okay, so Kaiser Permanente in the United States is an example of a nonprofit. It's a very large nonprofit. It's the largest, I believe, in the country. And any extra money that it earns every quarter goes back to Kaiser. Okay, so it goes back as maybe a wage increase or maybe buying equipment, things like that. All right, so we're going to talk about six forms of business organizations here. There's other forms, but we're going to focus on the six major ones. We're going to talk about sole proprietorships. That's just you as an individual conducting a business. We'll talk about partnerships and limited partnerships. We'll talk about limited liability partnerships. Everybody knows about corporations, and then limited liability companies. Okay, those are our six kinds that we're going to discuss. Sole proprietorship, it's the easiest to form. It's cheap. You just usually register your name as the sole proprietor. It's just you, sole, alone. Or you can use a fictitious name. And usually you just file it with your Department of State. And that's really all you need to do inside your state, whether it's California, Pennsylvania, New York, whatever, in the United States. Okay. Here's the kind of code for business formation in Philly. I know I've covered some of this stuff before, but I'm kind of going over it again just to make sure that everybody has it. We talked about already how the risk is the highest in sole proprietorships. And the reason why the risk is high is because other forms of business associations limit your liability. Okay, so they're designed to encourage you to do business and not be afraid of getting sued if you make a mistake, if you produce a product that harms somebody or damages something. You're still encouraged to go out there and do business, because if the corporation gets sued or the limited liability company gets sued, its liability, what it owes in the lawsuit, is limited. Okay, so or rather, your liability for starting that company is limited. Okay, so if, let's say, American Honda gets sued for a faulty vehicle, and let's say it's a big lawsuit, big judgment, they have to pay millions and millions of dollars. The employees who work for Honda, they don't necessarily have to pay out of their own pocket, even if they were involved in the problem, in the issue that led to the lawsuit. Honda has to pay out of its own bank account. Honda is a company, it's treated like a person, but the individuals that work for the company are safe. This allows Honda and its employees and its leaders to take risks, okay, to be entrepreneurs. That's how the whole system works, okay? So what corporations and business associations generally, not all of them, because sole proprietorship doesn't do this, but generally what they do is they lower your risk, okay? They lower your risk, and they encourage you to be innovative, and entrepreneurial. Okay, so that's the idea. So, and it's kind of a balance. It doesn't eliminate risk, right? So if you get harmed by a corporation, doesn't mean you don't have the option to file a lawsuit and be made whole again. It's just that you can only do so against the company. And so it limits the risk of the individuals, okay, without getting rid of the possibility that somebody who's harmed by the company doesn't have a way to get compensated. Okay, sole proprietorships. So, unlike the other forms we're going to discuss, the owner's liability is unlimited. Okay, so the owner has unlimited liability. It's not limited in this case. So, if you're a sole proprietorship, you're um, selling a product. Let's say you're running a bookstore or selling books online, and you do something where a lawsuit is filed against you, your liability is unlimited. Okay, your liability is unlimited, and your customer can take you to court. If you can't pay, they can sell your house, they can garnish your wages, etc. Okay, so that is uh, sole proprietorship. Okay, the next form, let's see, what do we have here? Okay, these are just examples of opening up a business in Pennsylvania. The next form we have is a partnership. Okay, a partnership. Partnership, you have to have more than one person, so because you're partners. It can be expressed, it can be implied. Express means, your partnership has a contract or an email, something is in writing. Implied means it's just, some sort of agreement. It can be a verbal agreement, etc. And then you have to find evidence. If there's a dispute about whether a partnership happened, you look for evidence of the verbal agreement. Okay, but you can have an implied partnership. This can be a handshake. This can be anything like that. All right. What do you need to find a partnership? This is kind of the general rule. Every state has its own rules, but generally, what you need to have some sharing of profits and losses. You need to have some joint ownership of assets, which means, it doesn't have to be equal, but it has to be joint. So I can own the building that the business is in, somebody else can own the product that we're selling. And there has to be equal right to management, right? So, maybe I manage this part, somebody else manages that part, but we have the ability to switch. Okay. So sharing, joint ownership, equal right to management. I mean, the theme is there has to be sharing. That's the theme. Okay, in order for there to be a partnership. In some states, if there's a dispute, you have to also prove the intent. So, excuse me, somebody might say, I never wanted to enter into a partnership. It was implied. I had a verbal agreement. Well, then we have a dispute about the intent, and then evidence has to be procured to show intent to enter into a relationship. Some more details about partnerships. It can be more than one partner. The partners can be unequal in contributions, right? So one person can give 50% of the upfront capital, another can give 25, another can give 25. Similarly, maybe based on the amount of capital that you put in, you can have different profit sharing requirements. So maybe the person who put in 50% of the capital gets 50% of the profit. And same thing with voting, right? Maybe the person who put in 50% of the capital gets 2 shares or 2 voting, the ability to cast 2 votes. Okay. Most of the time, these details are laid out in partnership agreements that lawyers help draft. Okay. Maybe some of you one day. All right. What about managing partnerships? They're usually governed by the Uniform Partnership Act. This is kind of a state. A lot of states have uniform codes and acts. This is to design so that if you form a partnership in state A and you move to state B to do business, you can be kind of relatively guaranteed that the rules that applied in state A also apply in state B. Okay. There's some legal ramifications of being in a partnership. So partners have duties. They have legal duties that the law imposes on them. And if they violate those duties, another partner or maybe even a third party can take them to court, okay, to say, hey, you violated this duty. So these are legal duties. Sometimes they're contractual duties. Okay, so a partner has a duty to be loyal to the partnership, to do work in good faith, to devote their time, to not basically check out. Okay, so if you're going to form a partnership and you're going to sign a partnership agreement, or even if it's implied, you have this duty of loyalty to the partnership. Okay, so this is not necessarily to the partners, but it certainly is to the partnership. Okay, to the partnership. However, partners also have a fiduciary duty to each other. To each other. We'll talk more about fiduciary duties, but a fiduciary duty is a kind of a legal duty. It's called a duty of care. And it basically says that you have to act in the best interest of the partners. Okay, so if I'm building a hotel along with three other people, they're my partners, and somebody else comes to me from another company and says, "Hey, if you put in cheaper carpet, I'll put you on the board of my company. Just buy the carpet from me." That's not necessarily a good idea. It's cheaper carpet. You're not acting in the best interests of your partnership, especially if the more expensive or the better carpet can be bought for the same price. Okay. So a duty to act in the best interest of the partnership. There's some liability issues with partnerships. Partners are personally liable, okay, for the torts or the civil harms committed by other partners. They also are agents for the partnership. In other words, anything that the partnership does, the partners can be personally liable for. Okay. And if the partnership goes into debt, they have unlimited liability. In other words, they have to put in their own money to front the partnership. So if the partnership is sued and it has, let's say, $10 million in its bank accounts, but because of several reasons, we are now left with a judgment of $11 million, the partners have to pony up the cash. Okay. They have to indemnify maybe they have to uh, fill in the liability for the partnerships. But let's say one of the partners gives more money than the others, then the other partners who gave less money, they have to indemnify their remaining partners. Okay. Reimbursement of their share. Everybody has to pay kind of an equal share. Okay. It all depends, right? I mean, so if you have a partnership agreement where you're 50, 25, 25, and the 50% person paid 75, then the other two partners have to indemnify him for 25% of the overage. Taxation. A partnership is not a taxable legal entity, generally speaking. So that means any profits and losses that are incurred by the partnership, they go to the individual partners. Okay, it's a little bit informal. And then the partners who get the money from the partnership, they have to include the gains and the losses on their personal income tax. Okay, so it's not a legal taxable entity. Okay, taxes pass through. This is called pass-through taxation. How do you end a partnership? When one of the partners leaves, if there's two partners, somebody dies, these terms are usually listed or worked out in the partnership agreement. Okay, sometimes a partnership is for a limited purpose, like the example I gave with the hotel. Partnership just exists to make the hotel. Once the hotel is built, partnership is over. Okay. This is pretty simple, but two-step process. You have a dissolution, you have a winding up. We don't need to spend too much time on this. Likewise, what happens after the partnership is terminated, there's kind of an order of operations of the distribution of the assets after the partnership is terminated. You can see here that third-party creditors are paid first, and then whatever's left over here is then given to the partners. All right, that's partnerships. Let's talk about limited partnerships. It's a different form of a partnership, okay? The difference is that you have divisions, you have a structure in a limited partnership, okay? So now you have somebody who's a general partner and somebody who's a limited partner. And the general partners, they have unlimited liability. In other words, their personal assets can be seized. Whereas limited partners are only liable up to a set amount, usually their contribution. Okay? But because they have limited liability, they also have limited powers. Okay, so their powers are limited too. So they may have limited voting, limited management powers. That's the price you pay for having limited liability. Okay. General partners also may be more involved in running the business. Okay. And everything else usually tends to be the same as a partnership. Who engages in limited partnerships? Usually you see this in the professions, what are called the professions. So you have doctors, lawyers, accountants. Another example is architects. God, I don't know if I can spell this. I'm not even going to try. Architects, okay. That's weird. I'm a lawyer and I can't spell architects. Limited liability partnerships aren't recognized by all the states. And I think that's all you really need to know. Same thing with the management. Yeah. Okay. All right. Now let's go on to corporations. This is the one that everybody's heard of. People may work for a corporation. Corporation is different. Okay, it has a couple of unique pieces to it. One, it has shareholders. Anybody can go out, depending on the price of the stock, and buy a share of a corporation. Okay, you can't do that with a limited liability partnership or a sole proprietorship, but you can do it with a corporation. So shareholders become a party in corporations. We really have a couple of parties. You have shareholders in a corporation. You also have the board. Okay, so you have a board, and then you have the employees. Okay, and in the employees, you also have kind of the directors, management, and then everybody else. And so each of these groups, oops, let's just use this here. Each of these groups have different legal responsibilities in a corporation. Okay. Corporation is considered a legal person. Okay. It can enter into contracts, it can hire and fire employees, it can borrow money, own assets, it can even commit crimes. In fact, in modern times, it can even participate in political activity, donate to campaigns, and so forth. How do you form a corporation? Again, relatively easy. You just fill out usually a form in your state, include this information, and there's your corporation. Many of them are formed in the state of Delaware. Okay, and the reason why is because Delaware is a hospitable climate for corporations. It has a sophisticated court system, court of chancery, with judges and lawyers who understand corporate law. So it's considered a hospitable place for a corporation to be formed because it can be sued there either by other corporations or individuals, and the judges will understand corporate law. It's kind of on the cutting edge. In fact, Delaware makes a large amount of its revenue from corporate formation and housing corporations there. Okay. Again, this is pretty self-explanatory, but some highlights here. You can have a corporation be perpetual. It can exist forever. Okay. All you need for the purpose in most forms is just to say for all legal purposes. Okay. Corporation issues shares of stock, and sometimes it even has classes, different levels, just like a general partner and a limited partner. You can have preferred shares, preferred stock, things like that. All right, we talked about management. I talked about the three groups here, again. Okay, so you have shareholders, you have the board of directors, you have corporate officers. And you can see there's a kind of a sharing of responsibilities, um, similar to executive, legislative, and judicial, but not exactly. Okay, so corporation issues stock, right? And the stock is a share, a part of the company, and that's bought by shareholders. They hold these shares, and what powers does that give them besides sharing in the good fortune of the corporation? They get dividends. They may get other financial benefits. They can sell the stock if it goes up and makes money. But they also, especially shareholders that own a certain percentage of the company, they can elect members to the board of directors. Okay, and that body, the board of directors, right here, the board of directors, they manage the company. Okay, so that's your 12 whatever person board of directors. They sometimes get paid, especially in for-profit corporations. They set the general agenda for the company, the very, very broad 50,000 foot level agenda. They manage the direction of the company. Are we going to make cars? Are we going to stop making cars and start making trucks? Things like that. They also importantly select the corporate officers. Remember, that's the third group I talked about. These are at the top level, the CEO, the COO, things like that, the CTO, the VPs, whatever, the chief legal officer, okay, or general counsel, sometimes called general counsel. And the corporate officers manage the day-to-day activities of the company at the top level. And then the third group here, which really falls under this group, or the rest of your employees that are not management. And these are non-management. Okay. I think that gives you all you need to know for these big ones here. Sorry if I'm yeah. All right, let's talk about limited liability companies. See if I can pull up that up here. In fact, I may do another video. Okay, I'll do another video for limited liability companies.